Keeping your corporation's legal documents up to date is crucial for maintaining your business's legal status and protections. Articles of Incorporation are foundational documents that establish your business as a corporation, and knowing how to properly amend them is essential for any business owner or corporate officer. Articles of Incorporation are the official documents a business must file with the state to become a corporation. These documents typically include the corporation's name, start date, type of corporation, stock information, registered agent details, and names of incorporators and initial directors. By incorporating, business owners create a legal separation between themselves and the company, providing asset protection and tax benefits. Over time, corporations often need to make changes to their original incorporation documents. 4 major changes that require amendments include address updates, company name modifications, changes to the business purpose, and adjustments to stock information. Failing to properly update these details can have serious consequences, including violation of state law and potential invalidation of your corporate status. So when exactly should you amend your Articles of Incorporation? Any significant change affecting your business structure requires an official amendment. This includes relocating your principal office, changing your company name, expanding or shifting your business activities, modifying your stock structure, updating corporate officers or directors in some states, and designating a new registered agent. Timely filing of these amendments is crucial to avoid state penalties and potential dissolution of your corporation. The amendment process follows several important steps. First, review your corporation's bylaws, which outline the requirements for making amendments. Next, schedule a board of directors meeting, providing ample notification time so members can attend. Before the meeting, prepare a written draft of the proposed changes that mirrors the language used in the original Articles of Incorporation. When holding the board meeting, ensure you have enough members present to constitute a quorum. Present the amendment, explaining the rationale behind the changes, and allowing time for feedback from all board members. Then conduct a vote according to the requirements specified in your bylaws. After board approval, prepare the final amendment using the proper forms from your state's Secretary of State website. These are typically found under Corporate Forms or a similar section. Submit the completed amendment to the Secretary of State either by mail or in person, along with the required filing fee. Finally, add the amendment to your original Articles of Incorporation for your corporate records. Be aware that amendment requirements vary by state. Some states allow online submissions, while others require mailed or in-person filings. Additional documentation may be needed, such as a certificate of good standing or shareholder resolutions. States like Arizona and New York have publication requirements, mandating public notice in a newspaper before an amendment becomes valid. While board approval is standard across states, some amendments may require shareholder votes, depending on state law and the type of change. Filing fees also vary, typically ranging from $25 to over $100, with expedited processing available for an additional cost in many states. For a simple address change amendment, your document would include the corporation name, state of incorporation, previous and new principal addresses, date of board approval, shareholder approval status if required, and the name and signature of an authorized representative. Many business owners have questions about this process. The time to process an amendment varies by state, but typically takes between 5 and 15 business days. Some states allow address updates through annual reports rather than formal amendments, while address changes generally don't require shareholder approval. Unless specified in the bylaws, board approval is typically necessary. The consequences of neglecting to amend your Articles of Incorporation can be severe, including fines, loss of good standing, and potential administrative dissolution of your corporation. Filing fees for amendments vary by state, typically ranging from $25 to $150, depending on the type of amendment and processing speed. Maintaining accurate corporate records through proper amendments ensures your business remains compliant with state laws and preserves the legal protections that incorporation provides. Taking the time to follow these procedures correctly will help your business avoid unnecessary legal complications and operate smoothly for years to come.